Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
And I'm Artur, Adamin.
Welcome to Hull on Estates. You're listening to episode number 648. How are you, Artur?
I'm doing very well. How are you doing today?
I'm good. Having a bit of a slight Zoom difficulty, but such is life, right?
It's not another day in the office if there's just one minor IT issue, one day at a time.
Yeah. And life's curveballs. Not everything goes as planned. We do this kind of stuff all the time on Zoom all the time, and sometimes it just doesn't work out. And I think we have a case like that today, the one that we'll be discussing, called the Pearce estate. And it also might just be something that, as law offices, we're in the business of doing wills. Sometimes you do have people coming in, lots of drafts are done, and at the end of the day, your end result might end up having some technical difficulties as well.
Technical difficulties for sure. Just like
exactly, and some real substantive difficulties too. So before I keep hinting at everything and go on with my very, very corny joke, Artur, do you want to introduce the case?
Well, absolutely. So this case that involved these challenges, aforementioned challenges, involved the deceased estate, Diane Frances Pearce. And so I'll go over the facts briefly, and I'll pass it over to you. But essentially what happened was that the deceased died with a number of wills, but the last one that was in front of the court was actually an outline. It wasn't a formal will, sort of didn't look like a will. We don't know what it looked like because we only have an endorsement, but the parties had to go to court for an application for probate with a will. And instead of going to the court with the usual normal looking will, as it always is, they had a technical difficulty. Would you like to talk about the technical difficulty, Doreen?
Sure. Yeah. So as you were saying, this is in the context of a probate application. So it is an application in writing, and what's before Justice McLeod is just a piece of paper. It must have been an original, but at the top, instead of something that you typically see as being the last will and testament of this person, the heading this time is called the outline of a will of this person. But this outline is actually signed by the testator, and it's actually witnessed by two witnesses, and the application was submitted with an affidavit of execution from one of those witnesses. So been talking a lot about these technical difficulties, but actually on the face of this one, it does seem like maybe a lot of the technicalities are being met, which is what we call the due execution requirements under the Succession Law Reform Act. Because the Succession Law Reform Act defines for Ontarians how you can make a valid will that will become binding on your death, that it can be acted upon and it can be actually used to give away the assets that you have left. There's no requirement as to any particular form of a will, but it has to be in writing. It has to be signed by the testator. And if it's entirely in the handwriting of the testator, then you can have only just the one signature. And then in this case, we do have two witnesses, and that is where you have the due execution requirements for typed wills. So you have not just solely in the handwriting of testator, it's typed. And I think that's what we have here with this these bullet points, although I'm not actually sure. It doesn't say. But it's so strange because as you're saying it doesn't look normal. It says it's an outline. And because it's an outline, it actually is in bullet points. So you don't actually even see like the typical paragraphs and like the provisions. It seems to suggest that significant changes were made, like they were big three lump sum gifts and the outline of a testamentary trust. So with like this concept that this is something that very much looks like a draft, but it's a draft that has become like properly signed under the act. What is then the problem? Well, the problem is actually like a substantive issue, which is there sufficient testamentary intent on the face of this document that shows to the court that this is what this testator actually really wanted for her assets when she dies, that this was her final decision, and this is something for the court to actually like endorse to like the world that this is the final intention of this person. She's dead. This is the executor, and this is how the executor should be distributing the assets to the beneficiaries. And I guess with, the way Justice McLeod goes through all of his concerns, you can very much see why this one is just not really all there. And the record is actually not really all there for him to really just be ready to sign off in that moment. So at the end of the day, he did ask, he did send us back for more information. So this isn't the last of it, like for this document. Artur, do you want to give some like specific examples to like what the issues were?
Absolutely. Definitely not a typical will, eh? An outline with just bullet forms. But so in terms of the parties being in front of the court, they did bring some evidence with them. They brought a few affidavits. One of the affidavits was from one of the witnesses, which was, I'm sure, helpful. And they attested that, they were there. They saw the deceased there present. They saw the other witness present. They saw everybody sign everything. And the second affidavit was from the solicitor. Now, that affidavit was also important because the solicitor said that, they believed that the deceased intended, there was an issue about the executorship. So given all these lack of formalities, it's an outline, there's bullet forms, it doesn't look like a usual will. Another interesting part about it was that there was a person named to be the trustee, and the will was set up to create a testamentary trust. So is this a trustee of the estate or is it a trustee of the trust? It's unclear. And so the affidavit of the solicitor stated that they believe that that the deceased intended to name that person to be the executor because the deceased was not familiar with the terminology, and the entirety of the trust was the residue of the estate anyway. So that was the evidence in front of the court, but Justice McLeod, being very attentive to detail and making sure that justice is served, like you said, took an issue with a few things because justice was really looking for that intention. The core issue here would be ambiguity as to the intention. So, Justice McLeod said, we have the witness who says they saw the document signed in front of the two witnesses, but they didn't really describe any of the circumstances or any kind of knowledge they had about the intention. We also have this affidavit from the solicitor who says, well, this is what the intention of the deceased was with regards to who the trustee should be. But similarly, the solicitor did not really include any kind of basis for their information or belief. So the only evidence is this piece of paper that says it's an outline of a will. It's signed in front of two witnesses, but why is it an outline? Why was this outline signed? What information is there that, the deceased intended this to be the will? And it just seems a little bit suspicious and unclear. So Justice McLeod sent the parties back to get further evidence.
Yeah. And I think like we keep talking around like this concept of intention and why it is so important, and why it was so important to Justice McLeod. With this idea that like what's in front of him seems like a draft, but it also seems like a draft that's been made final because everybody signed it, right? That's where it's like not so clearly obvious it's not a will, but it's not so clearly obvious that it is a will just yet. And it's this, like it's called a last will and testament for a reason. It has to be your last decision, your last will about what you want to see happen with your assets when you're gone. And all of those due execution requirements that I talked about earlier, it is actually designed to be able to like provide courts and like all of the parties, right? The beneficiaries, the executor, banks, et cetera, with evidence that like, okay, this is what this person wanted because they actually like took the time, had witnesses like sign it. It also like helps with like reliability against fraud, but it just like creates like this like sort of circumstance where it's like it's a solemn act. You're taking this seriously. This is your last will and testament, right?
Intention intended to be your last one.
Yeah.
This time.
And like with something that needs to be like really final and it's important. That's why there are all these like formalities around it. And very recently, the Succession Law Reform Act has been amended to include a remedial clause that still allows courts to validate a will when all of these like technical due execution requirements aren't met, but the court is satisfied from the evidence of like the circumstances before them, the document before them, that there is sufficient testamentary intention for the courts to save that improperly signed will and still give effect to the testator's intentions, because at the core of it, they see the testamentary intention, they're satisfied with this. Whereas like this one, they're like not so sure. Because another really big thing that's actually on the face of this outline is that it talks about, there's a line that says, to replace 02 April 2015 will drafted and the amendments dated 11 June 2014 and 09 November 2017. So it talks about prior drafts, and then the court's like left to wonder, well, are there any prior wills that has been validly signed? Because there's also like no revocation clause. So is this outline only one piece of the puzzle, or is this outline the whole thing? The court has no idea. And so like that's why Justice McLeod had sent this back with his litany of questions. And at the end of the day, this one was done like through a lawyer's office, which kind of does like make it even more strange as to why it sort of like was completed in like such a limbo way. So like hopefully maybe they can get some evidence from like the lawyer who did it and like the legal office. I'm actually not really sure if the lawyer who gave an affidavit is actually the lawyer who acted in the will, or whether or not he's just the lawyer hired to do the probate application, because he would have a lot more evidence to give if he was also the lawyer who did the will. But at that point, he's also a witness and he has, privilege issues to deal with. But all of that is to say, when you actually have these like unique circumstances when it comes to wills and the person is gone and they can't explain it to you themselves, right? The whole point is this is only in effect when you're gone. But you're gone, so you can't be there to tell people like, hey, this is what I want. That's why there's so much formality around these pieces of paper. And in a sense, that's why the probate applications take so long to process, because the courts do take it really seriously. They do review it for all of these like very technical requirements, and then they still have to sit down and look at it and be like, is the substantive requirement fulfilled? And this one, it just really leaped off the page that it wasn't, because it's an outline with a lot of missing information. So This case is a good one because it is, in a way, kind of like if Justice McLeod was like back in law school in estates. It's like he gets like, like this fact pattern of like this like really weird, strange piece of paper, and he's being asked like what to do with it.
Like a final exam,
This,
sure.
yeah, exactly. And this is an answer. It's an A+ from the court.
So, okay,
um,
let's say you're the justice. You're working away,
yeah,
and you get this will on your desk, and it's an outline, and it meets all the formal requirements, but you have questions about the intention. So, what else would you need in order to feel comfortable to declare, all right, this is the last will and testament of the deceased? What was missing here? Like, what else would you need? And then, how is that different from how Justice McLeod approached it?
I think the way he approached it is exactly how I would approach it too. Like I would want to hear from like everybody that was involved, all the witnesses. I want to hear from the beneficiaries. I want to know if there were prior wills, all of it. Like it just, the record before him was, unfortunately incomplete because it was filed based on the requirements of a probate application, right? And the probate application, all you need is one affidavit of execution. Here they included one additional affidavit explaining, like the trustee appointment. But because the will itself left so much to be desired, that's why like I think this one requires maybe more of a fulsome hearing and in order for it to be probated. So in a sense, this might be closer to like proof in solemn form, kind of like we would do a will challenge, except there are actually no allegations of any capacity issues. But really, it's like in a sense, a little bit of like say the knowledge and approval. Like, did you know and were you like approving all of this as your final last will and testament? Or, is it, did you think that like with every draft, you're just supposed to sign it and have like these witnesses, but it's still subject to change? Like, does this person actually expect to sign a document that's like fully typed up and proper? That's why I say A+ to Justice.
A+. Well, we do have, it's kind of interesting because we have these rules, formal requirements for a will, and then we also, the courts also have the ability to, overlook some of those rules as long as they're certain about the intention, they feel comfortable, okay, maybe this formality is missing, but substantially it's what the deceased intended, we're gonna allow it. This is sort of like the opposite, where all the formalities seem to be here in check, but the most fundamental, the intention, is not 100% clear. It's at the very least, it raises a sufficient amount of doubt in the court's mind. So do you?
Yeah, so the court's leeway in its ability to overlook some of these formalities is actually still extremely limited. It did not exist before January 1, 2002. Like it has to be signed exactly properly, or it's not a will, and it has its own like entire process now that this is like this remedial provision is like available. It's actually only available to people who died after January 1, 2002. And in the decision, I don't know like when this testator died, but at the end of the day, testamentary intention is not a requirement that the court can actually overlook, even in the remedial provision. So, okay, I think that concludes our podcast. And until next time, we want to thank you for listening. I'm Doreen.
And I'm Artur, Adamin.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our website.
Until next time.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.